Welcome to all. As a part of the course on insolvency and bankruptcy law in India, today we are going to discuss the concept of information utilities under the IBC. So in the previous class, we have discussed about insolvency professionals. Before that, we have discussed about insolvency professional agencies. So as already we have discussed, insolvency professionals, insolvency professional agencies, information utilities. So these are all considered to be foundations of IBC. So they are going to provide key role. They are going to play a key role in liquidation or CRP process. So today we are going to discuss about information utilities. Let us recap what we have discussed in the previous class. In the previous class, we have discussed about legal framework relating to insolvency professional. Then we have discussed about enrollment of insolvency professional, who can be enrolled as insolvency professional, we have discussed. Then we have discussed about eligibility, who can become the insolvency professional, like minimum 10 years of experience as an advocate. Okay, so CA, CS, CMA, or 10 years experience in the management after completing your PG. So like that we have discussed the eligibility criteria. Then we have discussed about the functions and obligations of insolvency professional. Then we have discussed the powers of insolvency professional. So these powers are not in one place actually. The powers of the insolvency professionals, they are provided in various sections which is scattered in nature. But we try to discuss under the CRP process and under the liquidation process. Okay. Then judicial interpretations, how judiciary has recognized the role of insolvency professional in liquidation and CRP process. So this is what we have discussed previously. Today in this class we are going to discuss about information utilities. Okay, so let me call it as IUs. Okay, so from now onwards I'll try to call it as IUs. So what is the importance of IUs? So IUs are entities which is registered with IBBA. So as already we have discussed, every entity, whether insolvency professional agencies or this IUs, everyone must be registered with IBBA only. Okay, so what is the purpose of this IUs? The purpose of this IU is to store, authenticate and provide access to financial information. Okay, so they are going to act as a data bank. Okay, so they are going to store and they are going to authenticate and they are going to provide the financial information, so which helps in resolving the insolvency cases. Okay, so when you are dealing with insolvency cases, financial information is very crucial. Okay, so to whom the corporate debtor owes the money, who are all having the claims. Okay, so what is the assets what are all the assets of corporate debtor. So this is very important. Okay, so that's why IU is the person who is IU is the entity which is going to provide all this information. Okay, so that is why it is very important. So that is why the role of IU is very crucial. Okay, so in establishing the debt and the default. So the default and debt, already we have discussed the meaning of debt and default in the previous classes. So in establishing the debt and default, the role of IU is very crucial. Okay, then let us look at the statutory framework dealing with IU. Okay, so IBC provisions are there, various provisions like section 209, which speaks about the registration of information utility. Then section 210, application for registration. Section 211, conditions for registration. 212, cancellation of registration. 213, core services of information utilities. We are going to discuss in detail all these things. 214, obligations of information utilities. Then 215, duty to submit resolution financial information. Then 216, access to financial information. Okay, now let us discuss in detail. So if you observe the regulatory framework, apart from the sections under the IBC, we are having IBBA information utilities regulations. Okay, IU regulations 2017. So if you observe these regulations, okay, so these regulations will provide for governance structure. So how governance system must be there in IUs. Then technical standards and data security, how you are expected to maintain the technical standards. Okay, so how to protect the data. Okay, then how to submit the data, how to authenticate the data, because the financial creditors, they are going to upload the information to the IU. Then how to submit, how to authenticate the data. Okay, so all these things are there in the regulations. Okay, then retention and confidentiality protocols. So they are not supposed to share the information with everyone. Okay, so how IU is going to retain the information, how IU is going to maintain the confidentiality. Okay, so all these things are there in the IBBA IU regulations 2017. Okay, then who is the authorized IU in India? Okay, so NESL, National E-Governance Services Limited. This is the only IU which is authorized by IBBA in India. Okay, so no person to function as information utility without certificate of registration. Now let us look at the sections. So as per section 209, which provides that save as otherwise provided in this legislation, in this code, no person shall carry on its business as information utility under the code without the certificate of registration. So without, this section provides that without having the registration from IBBA, no one can act as a information utility. IU services cannot be offered. Then registration. Section 10 of the IBC speaking about the registration. So whenever if you want to act as IU, you are expected to make an application for registration. Okay, so it shall be made to the IBBA, that is board, in the prescribed formats. Then once if you make an application to the IBBA, then IBBA is expected to give the reply within a period of 7 days. Then there is a checklist is there. So the formats are prescribed. Along with the form, you are supposed to attach certain documents. Okay, so once IBBA is satisfied that all the forms are the form is full and it is complete, then in such cases board may, on being satisfied, they can grant the registration certificate. Okay, then the certificate of registration must be issued in the prescribed format. So we having rules, regulations are there. So in the prescribed format only, IBBA is expected to issue the certificate. Then renewal will be issued from time to time. So even renewal will be there. So from time to time you are expected to go for renewal. Then suspension and cancellation of certificate. So if IU, information utility, so if they fail to satisfy the condition. So why? Because when IBBA is granting the certificate, registration certificate, okay, they must have prescribed certain conditions. Obviously they will prescribe certain conditions, okay, to be followed by the information utility. Suppose if information utility fails to follow the conditions which are prescribed by IBBA, then IBBA can cancel the certificate issued to it. Okay, so apart from this, there are prescribed terms and conditions are there when you can cancel the certificate. So when IBBA, that is board, that it has obtained, it thinks that the information utility has obtained the registration by making a false statement, okay, or misrepresentation or any other unlawful means. Okay, so if IU, while they are applying for the registration or while they are obtaining the registration from the IBBA, if they have obtained the registration by giving some false information, misleading information, or by means of any unlawful means, then in such cases, okay, IBBA can cancel the certificate of registration. Okay, or else if they fail to comply, as already we have discussed, at the time of issuing the certificate, IBBA is going to prescribe the terms and conditions, internal bylaws and terms and conditions. If IU fails to follow the terms and conditions, then in such cases they are going to cancel the registration. Okay, or else if IU, as per the act, they are supposed to follow the rules and regulations. Okay, they are supposed to follow the law. So if IU fails to follow the law, that is IBC, if they contravene any of the provisions of the act and the rules made thereunder, then also they can cancel the certificate of registration or any other grounds as may be specified by the regulation. So in the regulations, detailed grounds are given. Okay, so as may be specified by the regulations, if IU fails to follow the terms and conditions, then in such cases IBBA can cancel the registration, certificate of registration. Okay, then let us discuss about governing board of the information utility. Okay, so how it should be governed. Section 212 of the IBC provides for governing board of information utility. So the board may require every information utility to set up governing board with such number of independent members as may be specified by the regulation. So section 212 provides that the information utility, they are expected to form governing board. So this governing board must have such number of people as may be prescribed under the rules and regulations. Okay. So let us look at the rule level, So because if you read only section, you cannot understand. Okay. So at the rule level, okay, so the terms and conditions are prescribed. So if you look at rule 9 of Insolvency and Bankruptcy Board of India, IBBA, Information Utilities, IU. So IBBA, IU regulations 2017. Okay, so how the governing board must be? So the governing board must consist of managing director, independent directors and shareholder directors. Okay, so the governing board must have. So this is similar to the IPS. Okay, so insolvency professional agencies. Okay, so the governing board shall consist of managing director, independent director and shareholder director. Then provided that more than half of the directors shall be citizens of India and shall be resident in India. So another condition is that more than half of the directors in the governing board of information utility must be resident in India. Okay. So this is the composition of governing body in IU. Now let us discuss about obligations of IU. What they are supposed to do? They are supposed to create and store financial information in a universally accessible format. So in a universally accessible format, they are supposed to store the information, maybe in PDF documents. Okay, so they are supposed to store the information about the corporate data. Okay, so about the companies. Then they are supposed to accept the electronic submission of financial information. Okay, so under the legislation, certain categories of the people, that is financial creditor, corporate debtor, okay, resolution professional, they are all expected to submit the information to the information utility IU. So whoever is having an obligation to submit the information, if they are submitting, okay, IU is supposed to accept the electronic submissions. Okay, then accept in specified form and manner electronic submission of financial information from the person who intended to submit such information. If any other person wants to submit any information to the IU, yes, you can accept the information from such person also. Okay. Then please remember, they are expected to meet the minimum service quality standards. Okay, so the minimum service quality standards are going to be prescribed by the board from time to time. So you are expected to meet the minimum service standards, okay, service quality standards as may be prescribed by the regulations. Okay, then let us look at other obligations. Okay, section 214 of the act provides for, they are expected to get the information received from the various persons authenticated by all concerned parties before storing such information. So whenever they are receiving any information from other person, before that they are supposed to authenticate. Okay, so they are supposed to authenticate, they are supposed to verify. Okay, so verified by the proper information, verified by the proper sources. Okay, they are supposed to maintain all the information. Okay, then provide access to the financial information stored by it to any person who intends to access such information in such manner as may be prescribed by the regulation. So if any person, maybe who is involved in the CRP process, okay, if any person wants to have access to the information, so that's why even if you observe the application made by the operational creditor, if you observe in the previous classes we have discussed. Okay, so when operational creditor is making an application to the NCLT under section 9 of the IBC, okay, one of the attachment that he can give is information from the information IU, okay, information utility. So this information or data from IU is considered to be authenticated. Okay, so this will act as a evidentiary value. So that's why, okay, he is supposed to IU is supposed to provide the access to financial information that is stored by it, okay, to any person who intends to access such information during the process. Okay, then they are supposed to publish such statistical information as may be specified by the regulations. Okay, so from time to time IBBA is going to by rules and regulations, they are going to specify which information to be published. Okay, then have operability with other information utilities. Okay, so in India right now we are having only one information utility. Suppose if in the near future, if they are recognizing other IUs, then interoperability must be there with other information utilities. Okay, Now let us look at the core functions of IU. Okay, so the core functions of IU is, we can divide into various categories. So first category will be collection and storage. Okay, so the information utility, they are going to collect the data related to financial statements. Okay, so our financial information like records of the debts, then default records. So in case of corporate debtor, how much debt is there and how much there is a default and what is the security, whether the corporate debtor created any charge in favor of that. Okay, so is there any modification in the charges? Okay, is there any satisfaction in the charges? Did they filed with the ROC or not? So all this data will be there with the IU. Then security interest, then balance confirmation. So what is this balance confirmation? Corporate debtor owes some amount to one financial creditor. So how much amount is already cleared, how much amount is pending. Okay, so this balance confirmations, okay, and repayment history, how they made the payment, etc., etc. So all this data will be there, or they will collect from the various sources. Okay, so there is one of the core function of information utility, and this information will be useful while you are dealing with CRP or liquidation before the NCLT. Okay, then second core function is authentication. So first core function is collection and storage. Second core function is authentication. The financial information submitted is authenticated by all related parties. Okay, so how they are going to authenticate? It is the information is going to be authenticated by relevant parties only. That is creditors, maybe debtors. Okay, so that they are ensuring the data integrity, because information utility cannot go to third parties. Okay, so they can only verify the data from the financial creditors and operational creditors and corporate data. Okay, so from them only generally they are going to verify, they are going to authenticate all the data. Okay, then another core function is access and sharing. Okay, data stored. Okay, so access and sharing the data stored. Okay, so the data store that is done by the IU, it is going to be shared. Okay, any person who required, it is going to be shared, or they are going to give access. Okay, so with whom they are going to give, with whom they are going to share, to whom they are going to give the access? To the insolvency professionals first, because he is a professional who is going to deal with the management of the corporate data and who is going to do all the work. So that's why insolvency professionals, okay, they can have the access to the information. Okay, then creditors and adjudicating authority, because adjudicating authority is the authority who is NCLT, it is the authority who is going to approve it. So they are supposed to have the access. Okay, then corporate debtors, okay, for authentication and record verification. So even corporate debtor is also having access of the information that is stored with the IU, information utility. So these are all considered to be core functions. So core function includes collection and storage, authentication, access and sharing, giving access and sharing. Okay, so these three are considered to be core functions of IU. Now let us look at few judicial pronouncements which recognize the IU. So in the case of Swiss Ribbons Private Limited versus Union of India, the Supreme Court recognized the importance of IU. So because they have recognized that, they stated that IUs in reducing the delays and ensuring data accuracy. Okay, so IU is very helpful in reducing the delays. Okay, because under the IBC, time framework is very, very essential. So if you want to complete the process within the time framework, availability of the data is very, very crucial. So IU is the mechanism which is providing the data. So that's why, okay, so it is playing an important role in reducing the delays and ensuring the data accuracy. As already we have discussed, the data is going to be authenticated. Okay, they are going to verify from the various parties, financial creditors, operational creditors and corporate data. So it is going to be accurate. Okay, so and they are going to validate the use of authenticated IU records as an evidence of default. Okay, so whenever if any creditor is claiming the default, then how he is going to authenticate? Okay, so he is going to authenticate with the help of IU records only. Okay, so in another case la Kotak Mahindra Bank versus A Balakrishnan and another, in this case la NCLAT held that whether an applicant under section 7 of the IBC can be rejected due to lack of IU record. There is a question mark. Okay, so the court held that the record of default in an IU is not mandatory. So all the data may not be available with IU, but if it is there, it will add to the evidences. Okay, so other valid documents can also be provided, and even with the other documents also you can prove the default. Okay, so this is one of the option, okay, additional option available with the creditors. Okay, so while IU records are preferred, but they are not the sole mode of proving the default. Okay, so you have to understand that IU is established to maintain the data, but there is a possibility the corporate debtor may not give the data with the IU. Okay, share the data with IU, or even financial creditor, operational creditors also, all the creditors they may not share the data with IU. So that's why it is only additional right now. Okay, then in another case la Shubham Jain versus Gagan Ferrotech Limited, NCLT Kolkata bench held that the applicant submitted IU records with authenticated debt information. So the admission, when he submitted the authenticated information, admission was granted as IU record clearly established that there is a debt is there, there is a default is there. So as already we have discussed previously, debt and default are one of the primary essential conditions to be satisfied whenever if you want to file an application under the IBC. Okay, so IU record are going to clearly establish the evidentiary value. Okay, so evidences. Then in the case of State Bank of India versus Veterinary Limited, in this case, NCLT principal bench held that IU records authenticated by debtor were given significant evidentiary value because it is considered to be an organization which is solely created for the purpose of data. So that's why any data or any document from IU will have some weightage. Okay, evidentiary weightage will be there. Okay. So NCLT emphasized on the sanctity of the data authenticated through IU process. So now let us see the importance of IU in CRP process, how they are going to play a crucial role. So IU is going to reduce a reliance on physical documentation. So because collecting the physical documents from various sources, okay, when you are talking about a resolution process, okay, you are expected to collect the data and collate the data from various sources, like financial creditors, operational creditors, from the banking institution, workmen, etc., etc. So it becomes very difficult for you to collect all the physical data, and they may not be willing to give also. So that's why, okay, so when the data is uploaded in the IU website, it becomes very easy for you, and it becomes very easy for you to download the data also. Okay, then ensures the speedy admission of insolvency applications by the NCLT. So NCLT can verify the data from the IU. Okay, then they can admit the petition or admit the application based on the evidence. Then strengthens the trust in data due to authentication mechanism, because we are having proper authentication mechanism is there, that is in place. So that's why the trust in data can be improved. Then used as prima facie evidence of debt and default under the IBC. So please remember, the data with IU is considered to be prima facie evidences. Then how it is going to impact practically. Okay, so IU are increasing the transparency in financial transactions. Why? Because there is no scope for you to hide any information. Okay, once it is uploaded, it is there. Okay, so that's why it increases the transparency, and it helps in prevention of frivolous claims and disputed defaults. Okay, so if it is not supported by IU, your claim may not be proved easily. Okay, so because it has to be the IU process is authenticated process. Okay, so that you can prevent the frivolous claims. Then it helps in support efficient functioning of NCLT in admitting the CRP applications. Okay, so these are all the practical things. Okay, encourage better financial discipline among the borrowers. So once the borrower borrows the money from any financial creditor, then automatically such data will be shared with IU. Then if such data is shared with IU, the borrower is cautious that the information is available in the public domain. I mean, information is available with the IU, so anyone can have the access. So he will be very cautious about that. Okay, so this consciousness in the corporate data or in the borrower will increase the tendency to repay the money quickly. or to repay the money as per the schedule. Okay, so this is going to improve, or this is going to facilitate the financial discipline among the borrowers. Okay, now let us look at the challenges and criticism. So limited awareness is there. So though the IU system is very good, it looks like very, effective, but the fact is that there is no awareness among the small financial creators and operational creators. Okay, these operational creators, majority of the cases, they are all small vendors. Okay, so they don't have awareness about IU. So there is a basic problem, major problem. Okay, they don't intimate IUs. Then there is a tendency, there is a possibility that they may lose their claims. Okay, because of lack of evidences. Okay, so limited awareness among the small financial creditors and operational creditors, that is one of the major problem that we are having. Okay, and one more problem is that right now we are having only one IU, that is NECL. Okay, so it may lead to monopoly concern. Okay, so whatever the player is saying, that can be the final. Okay, so monopoly concerns can also be there. Okay, then data authentication is sometimes delayed. Okay, so when data, because whenever if any document is uploaded, it has to be approved or authenticated by data also. He may not authenticate easily, so sometimes it is delayed, so reducing the effectiveness. Okay, if this authentication process is delayed, automatically it reduces the effectiveness. Okay, so these are all the various challenges and criticism that we are having in the IU system. So let us conclude. So information utilities under the IU, they are going to play a pivotal role in innovation. Okay, so majorly they are concentrating on transparency, speedy disposal of the cases, and efficient disposal of the cases. Okay, then NC, it is also going to help the NCLT in collecting the data. Why? Because even they can directly have the access to IUs, and even it helps the corporate debtor and as well as financial creditor, operational creditors. Okay, so their authenticated records have emerged as a reliable and persuasive form of evidence. So while you are arguing the case or while you are submitting the resolution plan, these evidences will help you a lot. Okay, so that's why these evidences, the IU data, will help in streamlining the process or proceedings before the NCLT. So that is the major role that is played by the IU as a data bank. Okay, so this is the importance of IU. Now let us conclude with a recap. Okay, what we have discussed today in today's class. In today's class, we have discussed the legal framework relating to information utility. Then we have discussed registration of IU, how you are going to register. Then governing board of IU. So in the governing board of IU, you are expected to have the managing director, then shareholders, directors, independent directors. So how it should be, we have discussed. Then core functions of IU, we have discussed. 3 functions are there corely. Then importance of IU, why IU is important, how it is playing an important role in IBC, under IBC. Then challenges that we are facing in this system. So these are all the various things that we have discussed today. Thank you.